guided choice neutral's ability to probe for the reasons why disputing parties have run into a settlement impasse, whether it's one that they are dealing with now or a prospective future impasse, is his or her most important resource and tool. If a mediator is involved or might become involved, it implies that the parties are stuck, right? If they could settle the dispute themselves, they would. Okay. And achieving that early cost efficient dispute resolution, achieving that amicable settlement that should be in the interest of all parties is more likely when the disputing lawyers and their clients understand the true reason for the stalemate, why a dispute persists as unresolved despite prior settlement efforts. Now, the neutral, otherwise known as the mediator, using the mediation privilege of confidentiality, right? It's certainly been my experience that everything that I've shared with the mediator and all the many mediations I've handled has been kept confidential, even though I'm aware that there are some concerns about the ability to get around that confidentiality. The neutral, using this ability to have private and confidential discussions with the disputing parties, is uniquely qualified to figure out, the reasons why an impasse is developed, and to suggest a settlement process that is customized to the individual dispute and is designed to address any obstacles to settlement. So, for example, after the neutral has confidential discussions with both parties and is able to undertake his or her diagnosis, the results might be that one or more parties lack sufficient information to form a position on whether a settlement is in their strategic interests or not. Or it might be the case that there are some missing parties, that there's some relationship issues, some interpersonal dynamics or inter-party dynamics that could be resolved by adding additional participants. And so, these confidential discussions, which really ought to remain confidential, with the neutral, certainly. While I'm not naive about the importance of ensuring confidentiality, I'm not overly concerned that what I discuss with a mediator is likely to be shared if it's something I don't want to be shared. This is a very important tool in the mediator's toolbox. And, I think these confidential discussions are much better had over phone calls or Zoom, certainly more so than formal writings, because the things that people tend to write in their mediation briefs are usually not the thing that is really driving the impasse. It usually is, some dry legal position that parties are setting out on paper when there are a much wider variety of issues that are sort of driving the people who will make a decision to settle or not to take the positions they're going to take. So, I don't like these confidential discussions to be in formal writings. I think verbal exchanges are better. They tend to be more frank, open, and honest, and they tend to be more free and instinctive and spontaneous. And, while this is something that may concern some counsel, and I'm not entirely without some concern there, I'm happy for my client to be given an opportunity to speak to the neutral, because I would like the mediator to figure out what is it that makes our side tick. What are our needs? What does it need? What needs to be done for our side to be satisfied, to be put into a position to make a business decision about whether it's in our interests to fight on in litigation or arbitration or to settle. And these private, confidential explorations that the mediator is able to undertake about the reasons for the dispute and why it persists with the disputing parties, it empowers these key stakeholders, to pull back and look at from 50,000 feet about what's happened in the past, and really to achieve true insight in the reasons for past standoffs, settlement roadblocks, and to work with the neutral and counsel to recalibrate the process, to anticipate and circumvent and hopefully overcome, future bases for impasse. The guided choice dispute resolution neutral absolutely needs to do more than just read legal briefs submitted by the parties. This is a distinguishing factor from guided choice versus traditional mediation. They need to effectively diagnose the reasons for the impasse and to create a sensible process. And so, my mentor, my former law partner at Schiff Hardin, Paul Lurie, has taught me many things, including everything I know about guided choice. But he helped me understand that in this confidential discussion and diagnosis phase, mediators really they act like psychologists and investigators. Exploring human and social factors that are animating the positions that the humans are taking, the people who are going to make a decision to settle or not. And the mediators need to interview the key cast of characters to figure out the key information on these settlement roadblocks that have occurred in the past and may in the future. And not just interviewing the business people who are involved in the disputes, but the disputing parties counsel. And sometimes their insurance claims representatives and other people with an interest in the outcome. And this all absolutely requires going beyond the parties' explicit positions that have been taken in mediation writings to gain an understanding about what makes the decision makers tick. What is it that has led them to take the positions that they've taken in the past, and the positions that they're likely to take in the future. And usually this is something that can be accomplished in a day or two. So it's not something that necessarily has to really drag uh, the process out. And this diagnostic phase, it definitely has a number of objectives, and it includes identifying, as I suggested a second ago, who needs to participate. What are the identities of the key stakeholders or individuals involved? It's usually the case when I'm involved in a mediation, I'm going to have a pretty good idea about who I need to be physically at the table from my opponent to make sure that the messages that I'm bringing forward in the mediation are not falling upon deaf ears, not falling upon the deaf ears of maybe the people who are lower level in the company and maybe involved in creating the dispute, maybe the people who are involved in not filtering the true information up to their superiors because they're concerned about losing their job or losing their bonus. So we have to figure out who are the identities of the people that need to be involved. This can be insurers, it can be third parties, people who may not be legally obligated to participate in a traditional mediation, but might be a positive influence on the process if we could figure out a way to get them involved in this guided choice dispute resolution process. And many other things cited, by Paul Lurie and, his collaborators in their many writings on guided choice, like, financial constraints, timing constraints, legal, social, or other constraints that the parties may face. There's a wide variety of things below what parties write in their mediation submissions that are going to drive their behaviors, whether it's, their idiosyncrasies. I think I got the word right there. Their predispositions, the culture of their company, particularly, if it's a large corporation or a government. These are things that the decision makers have to contend with. There's a wide variety of possible group dynamics and emotive drivers of disagreement and claims, whether it's risk aversion or antisocial conduct or other psychological factors that tend to lead parties to impasse. Sometimes coalitions can have developed where, within all the people that are involved in the mediation, some are sort of clustered together working against, other parties. And sometimes it can be constructive, sometimes it can't. And certainly the diagnostic phase should involve things like looking at what would lead a clash of parties, what would lead their disagreements to intensify, to become worse in the future, so that we could steer clear from that sort of a dynamic if at all possible. And hearing from the horse's mouth, hearing from the key stakeholders involved in the dispute, how they frame the dispute, for example, right? Is it about liability and entitlement? We didn't do anything wrong. Or is it about, okay, well, it's really about dollars, not about, whether we did something wrong or not. Hearing how they frame it, just the words they use can be essential to arm the guided choice neutral with information they need in the diagnostic phase to carry forward a constructive process. Certainly, information, the needs of the parties for the exchange of information, in order to have an influence on their readiness to negotiate dollars is important. what information has been exchanged, what information needs to be exchanged, so that the neutral can recommend a mediation process design based on this diagnosis, which, would help the parties understand what are their best, worst, and likely alternatives, to reaching a settlement. Can they improve on these alternatives? What's the range of their options? Are there win-win scenarios available based on, perhaps a broader view of the dispute, taking into account what might happen in the future between the parties potentially working together in the same markets? A wide variety of different interests, whether they're social considerations or business considerations that are not directly linked to this dispute. And so, these confidential discussions with the neutral, which I would hope would be, verbal exchanges that are frank and open and honest, all cloaked within the mediation confidentiality privilege, are really important to allow the neutral in the diagnostic phase to anticipate what's going to be necessary in the future to overcome and deal with impasse when it arises, all part of a process, a constructive process that hopefully the parties can agree upon and they can march forward through together so that they can have the best chance of figuring out whether it's in their strategic interests to go for that early cost-efficient dispute resolution or to make a thoughtful decision that this is one of those cases where it makes sense for us to fight on in litigation or arbitration, despite the many downsides of proceeding in those binding dispute resolution forums.